Good morning. I am soon-to-be eccentric, reclusive billionaire Drew Coursin as of tonight's Powerball drawing. I am an attorney at Neider Boucher, which is a relatively small but powerful law firm on the west side of Madison. We specialize in business of all shapes and sizes. In particular, I focus on startups because I'm one of the few guys under 60 there, and I can be embedded in the startup community without freaking people out, and I know what Snapchat is. So that's my role there. We also do all kinds of stuff like employment law, real estate, estate planning. So if you have any legal need apart from like high-level antitrust litigation, which we can certainly find someone for you, give me a call. There are cards, and take a screwdriver. So I'm also an organizer here at A Million Cups, and I would like to know who all of you are. I mean, spoiler alert, I know who most of you are, but we can quick go around and do some introductions. That'll give me a good sense of where we are. So. Oh.
My name is Steve Mist. I'm a marketing consultant in marketing technology.
Corporation.
Hi, I'm Eric. I'm a technology consultant with Accenture, but with a soft spot for helping local entrepreneurs when I get the chance.
My name's Ed Graves. I'm a business and technology librarian.
Hi, I'm Varun Bhargava. I work for Retail Next.
Hi, I'm Nikolai Fenev. I'm currently a student at Madison Technology College.
I'm Irina Broad, and I work for Nordic Consulting.
I'm David Israelstam. I'm a retired psychiatrist with a PhD in medical physics. I'm one of the over 70 people, and I'm reading a book called Startup Communities by Brad Fold, and he says inclusion is one of the possibilities, and I have no idea how to possibly connect to this group, but I thought I'd come and see what's going on.
Hi, I'm Elizabeth Blake, retired editor, writer, proofreader, currently a companion for an extremely smart 94-year-old woman, and on my toes.
I'm Patrick Reese. I'm a volunteer with Score Madison. We do free business consulting and advice. I'm also one of the few people under 60 in the organization.
I'm Garrett Lee, founder and co-creator of Whoa, We Help One Another, and Good Point, and I run that startup out of 100 State.
Great, and I'm Leah Anderson. I'm one of the organizers of 1 Million Cups Madison with Drew, and I work for Nordic Consulting as well. And I did want to just take a chance to thank our sponsors for this week as well. Baker Tilly has generously donated all of our coffee from Crescendo this month, and so you guys should check out Crescendo as well. They're an independently owned coffee shop on on Monroe Street in Madison, and they're really wonderful. And also want to thank Field 59 back there on the video. They provide our live stream each week. So if you're ever able not to make it in person, you can always check out the live stream on our YouTube channel, or if you want to check out past presentations, you can also find those there. So thank you so much for all of your help, Field 59. And take it away, Drew.
Thanks, Leah. And thanks, everyone, for coming. You'll find this is a very accessible and welcoming community. This is a good entry point. You could also stop by 100 State, which is a co-working space and entrepreneurial community itself just across the street. There are meetups and a full calendar of events and people who are willing to welcome you, so feel free to connect with me or any of these people afterwards. Welcome. I've also read that book, and I really like the idea of fostering a true entrepreneurial ecosystem where we celebrate the success and we literally mourn the losses with, startup wakes. I know Brad Feld talks about those sometimes, but I just find that a fascinating model. So, as for today, I'll say a few words about some common legal mistakes that startups make. I know that some of you are actually involved in startups. It sounds like a lot of you are professional service providers, or at least ancillary to the startup community, so this is good information for you as well. This is a presentation that I've adapted for a few audiences, typically a larger scale, longer form presentation, but in this case we can do a very high-level overview, run through about a dozen different areas where startups typically find themselves either having made mistakes or just about to make mistakes. And we can run through those, and then I think the real value would be from your questions and our interaction. So excuse me if I go quickly, feel free to stop me. This isn't meant to be a comprehensive cut-through of all legal issues that startups face, but it's a good 10,000-foot overview. So like I said, this should be interactive and congenial, and you can yell at me if you want, Varun, but yeah, let's do it. All right. So, by way of introduction, the various areas of dangerous ground that startups will face really happens from the very inception of the idea all the way through spinning out to sell your company and raising millions of dollars. So this isn't unique to very early stage companies, but really any company of any size. So today we can talk briefly about topics of entity choice, how you deal with equity or ownership of your company, employment issues, whether you're bringing on full-time employees or partners or independent contractors, intellectual property, how do you protect it, what is it, and what do you want to do with it. Financing, by financing I mean raising money. So are you looking at your couch cushions? Are you begging your friends, family, and fools for it? Are you going to a bank? Are you looking at institutional investments or venture capital? Tax. This is an area that's fraught with issues even for the most savvy business people and attorneys. It's a very erudite, granular area of law, and for startups there are some big high-level points that you should understand. And then finally, how to deal with your professional service providers. And I think this will resonate with a lot of us because we are professional service providers, and I think we all face similar challenges in that it's hard to sell a valuable thing to someone when that person has a whole list of important priorities and not a ton of capital. So we can talk about that. First things first, a lot of startups want to get creative and they want to be different from everybody else because the fundamental business model is different. So they think that translates to trying to be unique or crafty in the way they actually form their entities. I am biased, I admit, because I come from a firm that is more or less the primary evangelist of the limited liability company in Wisconsin. My boss, Joe Boucher, was one of the drafters of the LLC law, and we push LLCs at every level of business. It's easy to set up, it's relatively easy to run because you more or less write the playbook, and you can always convert to a corporation. It's more or less a win-win situation. So I think the mistake that I'd like to point out here for a lot of startups is they want to look beyond the LLC and the corporate model, and they say, well, maybe we're a limited liability partnership or a limited partnership or truly a limited liability limited partnership, which is technically a thing, but I've never seen one, and I don't know why you'd ever do it. The biggest mistake here is that people talk to their accountants, and their accountants mention, oh, maybe you should make an S election or be an S corporation. And that's fine for a very specific niche of businesses, specifically ones that are making a lot of money already, because there's a certain tax offset benefit to not having to pay certain taxes. But for the vast majority of startups, you just want to keep it simple. LLC, or if you're poised for venture capital funding, or if you have some compelling reason to, C corporation. So basically, the layout of my slides here and the thrust of this whole presentation is I'll point out the mistake, a basic solution, and most important, the reason why. And the why here is that you want to position yourself as a startup to grow and to interact with other forces. Specifically, if you're looking at raising money, you want to be as understandable and transparent and simple as possible to look and say, hey, venture capital, here's our business plan. This is what speaks for us. The legal stuff, it's taken care of. So that's entity for you. Equity. This is another big issue. Is when I say equity, I mean ownership of your company, whether it's units in your LLC or stock in your corporation. What do you do with the day after you start with 100% of your company? Say you're a sole proprietor of a company and you own the whole thing, but you meet a graphic designer who you really jive with and you want to give part of your company away. So you give that person 5%. And then you have a partner who wants 40%. And all of a sudden you have parsed out your company to various people or entities, and you don't have as much of that thing, of your little baby, as you thought you did. And that itself is a problem, but I think more fundamentally is that, a lot of startups either give or sell equity quickly without thinking about the entities or people to whom they are granting or selling that equity. I've seen a lot of startups working with other companies, like service providers, like graphic designers, marketers, lawyers even, who will take equity in lieu of cash. And I think, that's attractive to a lot of startups because, it saves them money, and they don't have a lot of cash on hand. But down the line, they have to worry about who actually owns significant chunks of their company. And that's problematic, especially when you grant equity to an entity. Say I hired Eric's firm to do some consulting for us, but I granted the equity to his firm. And sometime later, Eric has brought on certain partners I don't know and retires from his firm, and now that group of people that I've never met owns potentially a large chunk of my company. So I think one of the solutions here, and you'll have to forgive the pun, but that's a vest in the back end, get it? Is vesting. Basically, that is laying out some restriction on this equity that you're parceling out to ensure that the relationship and the expectations and then the ultimate prize for that relationship, i.e. the equity, are all in line. So you say, Brune, I'd love to work with you. If in exchange for your services, I'd like you to get 10% of my company. But, you will own 100% of that once you have fulfilled X, Y, and Z milestone. Then you can get as complicated as you want, whether it's purely time dependent, where you say, every year you vest another quarter of your equity, or it can be performance related. You do 25 hours of service, we raise $1 million. The sky's the limit, really. But I think it's important, and I think the kernel here is that companies should be really cognizant about how they parcel out their equity and their ownership, and ultimately what that looks like and who owns their company. So the why here is, both you, the founders of your company, and this actually is true for founders as well. If you have a group of people, you may consider having a part of their equity vest over time as well. It's tempting in the beginning of a company, I think, to say, hey, we're 4 buddies, we're all getting along, we each own 25%. But if one person just absconds, then what do you do? So, I don't mean to be doom and gloom about this whole thing, but I think it's an important lesson that you want to, again, keep it as simple as possible and really forge the path forward as clearly and succinctly as possible. So the next big mistake or big challenge that startups face is, how do you deal with bringing people on? And this isn't necessarily other founders. You say you have your core team, but almost every company needs to actually hire people, whether it's full-time employers or independent contractors. I have strong feelings about where independent contractors are going in the future and whether they will exist, but that's a topic for another day. But assuming that your company is going to hire people, what do you do? I see a lot of companies that are, especially in the tech space, that is, it's nimble, and you have developers who are highly skilled and highly sought after, and maybe working at a dozen different startups, and there's nothing written down. I think a lot of people think that having a contract is somehow a barrier to a good relationship, but I posit that it's just the other way around. This contract, or the agreement that you have, is a memorialization of your understanding with each other, and I think that's a great thing, and it's extremely useful to keep the board clear and keep the lay of the land, so everyone understands what their role is, what the expectations of their role is, and ultimately how they interact with the company. So again, you'll see some resonant themes throughout, keeping things simple and making sure that how you set up your company is understandable, both to yourself and to outsiders. So here, when it comes to hiring people, I think a good rule of thumb is put it down in writing. There are a lot of compelling reasons in an employment law context for that, and the way that taxes are involved with workers' comp or unemployment insurance, but beyond that, it's important because you need to understand where you are as a founder versus where the people that you hire are as your employees. So intellectual property, I think, to people who aren't steeped in IP law or IP in general, so if you're not a scientist pursuing a patent or a lawyer who works in this space, I think the term intellectual property makes you probably think of patents. And that's understandable because, I mean, patents are a crucial part of intellectual property. But I think what happens to a lot of startups is they have what I call patent myopia, where, especially, again, in the tech space, you'll go in and you'll say, oh, my software, my platform, or my product is unique, it's great, I need a patent. And while that's true for, a lot of companies, it is equally untrue for, I think, more companies. When you look at a thing, I mean, it's certainly worthwhile to talk to a patent attorney if you suspect you might need a patent, but I think you shouldn't have tunnel vision about patents being the end-all be-all of your intellectual property. I think more important is how do you protect the thing that you create? And what is the thing you create? Is it a brand? Is it content? Is it a secret formula or, the secret sauce that helps drive your product that has value because nobody else knows how to do it? Those are all totally independent of patents. In fact, they're kind of the direct opposite of patents because once you file a patent, everyone in the world knows exactly what you're doing. Versus, I have TM, TS, and C. That's trademark, trade secret, and copyright. So trademark is more or less your brand. So it's a logo, it's a slogan, it's the name that really embodies who you are. And that's important because I think, part of identity is actually physical identity. So you look at the Coca-Cola logo, or you look at the Nike swoosh and you know it's Nike. That's true branding, and that's trademark. Trade secret is a little more complicated. It's something, like I said a little bit ago, it's something that has economic value by virtue of being secret. And it's something that you take careful steps to protect and keep secret. And if someone else found out about it, it wouldn't be valuable. Which, like I said, is the opposite of a patent. But in many cases, equally protective, like the recipe for Coca-Cola. It's never been copyrighted or trademarked or patented. It's a trade secret because it's secret. And it's extremely valuable, obviously. So I think startups, rather than, if you suspect you might need a patent, explore that avenue. I'd be happy to give you some names of some very qualified patent attorneys. But for the most part, you really have to think carefully about what it is you're trying to create. Not just your identity, but also the content of what you're putting out into the world, which is more likely than not copyrighted. Because copyright is really the expression of any idea that you have put into a fixed medium, including the internet. So, some food for thought there. Financing, I think this is probably the hottest button issue that startups, and particularly my clients, are facing right now. It's how do you get money? Once you make it past the first couple of months and the honeymoon period is over and you realize that you actually need capital to sustain and grow your business, you have to think hard about where you're getting it. I think the mistake that a lot of startups make is that they're willing to either give or sell their equity for what I think is very cheap, especially in Madison. If you look at the coasts, you have sophisticated angels and venture capitalists who I think over the years have realized that there's a certain give and take when it comes to buying into companies. So they won't ask for as much, which is ironic because they're much more sophisticated and ultimately more powerful because they have a ton more money. But if you look around in the Madison market, you have this class of emerging angels and venture capitalists who are willing to give money, but one, it's a relatively modest amount of money, and two, they want a lot for it. And I think the mistake is that startups say, oh my God, we could get $250,000, we just need to give up 20% of the company. And that's a lot when you think about it. In addition to, the seat on the board of directors and some additional dividends. When you break it down, it's easy, and I think it's extremely tempting for startups to really, have a fire sale and give away all of their soon-to-be very valuable intellectual property and, growth potential. So I think what I would caution people is to be more circumspect about how they are dealing with investors. Obviously, the leverage is in favor of the investor almost all the time, unless you have an idea that has already penetrated a certain market or has already proven itself to be valuable. If you're a startup and you have just a great idea and need the money to create it, you're kind of over the barrel. But that doesn't mean you have to give up your entire company for more or less nothing. I think, this speaks to one of the greater themes of long-range planning, and actually planning in general, and being able to map out where you'd like to be today and where you'd like to be in 6 months or 18 months or 5 years. And obviously this isn't a one-size-fits-all scenario for startups, but I think just being more thoughtful than going out and saying, hey, if you'll give me $10,000, you can, have your name on the door. So this is where it gets a little complicated, I guess, and I think understandably so, that a lot of startups don't pay attention to the tax consequences of what they're doing. And this isn't, the simple stuff, but the stuff you think of, like, oh, do we pay unemployment insurance taxes for our employees? Do we do W-2s? Did we do Schedules K-1 for our members? I mean, those are all the standard tax issues. But I think more likely is that, even a tax preparer or, an accountant who can count to 10 will tell you about those issues. What they may not tell you about are 83B and 409A issues. In a nutshell, we can talk about these if you have questions, and I know I'm trying to gear this more toward the audience of not a ton of startups in the room today, so this might not be particularly relevant, but we can certainly talk about it. In a nutshell, 83B deals with how you value restricted equity. This goes back to vesting. If I gave Varun, 100 shares of my company, subject to vesting, he could make what's called an 83B election and get taxed on the value today, rather than normally, if he didn't make that election, he would be taxed at every point of vesting, which in all likelihood, and if all things go as planned, that stock will be more valuable in the future. So he'd be saving a ton of money on taxes. Simple thing, but something that just doesn't come up, and it certainly isn't common sense like every aspect of the tax code. On the flip side of that is 409A, which deals with, technically it deals with future earnings and deferred compensation, but that speaks directly to startups that are granting options, which in a broad sense an option is the opportunity for someone to put money into a company and get equity in the future. You'll hear employee stock options or unit options most commonly. And the issue there is that 409A came up historically. People were able to grant options at virtually no price. So I could say, hey Garrett, you're doing a great job, I'll give you 1 million stock options for $1. And then, down the line you would exercise, you'd pay me $1, have 1 million shares of my company. And that would have a terrible effect on everyone else who was already in the company. So back in 2004-ish, the IRS got wise to this, and they issued this 409A, which basically says that any options have to be issued at fair market value. So this is important for startups because they are tempted to do what I just did with Garrett, with their employees, while at the same time raising money at a much higher valuation. And what they can easily fall into is say, okay, so Garrett, I gave you 1,000 options at $10 a piece, so $10,000 bucks. And then I say, hey, Mr. Venture Capital, I'll give you, 1,000 shares of my company for $500,000. The price per share there is so vastly different, and you did them more or less contemporaneously, that the IRS is going to hammer you under 409A. Again, not a common sense topic for startups, but incredibly important. So, again, this speaks to working well with professional service providers, doing strategic long-range planning, and doing planning in general, just mapping things out. Finally, I think this will resonate with most of you, is that startups often overlook professional service providers. And I think, I don't have a strong sense of a hierarchy of professional services. If you talk about legal, accounting, marketing, I think of any kind of business consultants, anyone who has a particularized set of skills that would be useful for a startup, but at the same time costs money and is valuable. And this is the problem. I mean, this is something of an echo chamber, I realize, because I'm preaching to the choir saying, hey, look, my services are valuable. I know that. The clients that pay me know that. But how do we bridge the gap between, and even the startups know that, but how do we bridge the gap between our services being valuable and therefore cost money with the sense that startups simply can't afford anything, much less, a great lawyer or a great accountant or, actual strategic business consulting. And I think the mistake that a lot of startups fall into is making mistakes and then running to professional service providers and saying, hey, we did this, help us. And I know, in hindsight, it's easy to say, well, you should have hired a lawyer, you should have hired an accountant. But I think it is absolutely true that fixing these mistakes is far more costly than not making them in the first place. So that's where I think, the tone of my presentation typically shifts in this area to say that I and Neider Boucher and a lot of other attorneys and service providers that I know across the board are really trying to figure out the riddle of startups. We are not startups ourselves. We are entrepreneurs. I mean, we're small businesses as well. And I know a lot of service providers. I know, Eric, you've done business consulting on your own. You are a startup. You're an entrepreneur. You're in an area where, you have to get clients and need to keep food on the table. I think all of us have been in similar situations. So I think, the challenge and what I, want to put forth to you, not just is the value of legal services, which they are very valuable and you should hire an attorney, but also I think, a philosophical question about how do we as professional service providers and we as startups and business people and we as people who are neither of those things but may become either of those things, how do we find a way to cultivate that community and make it affordable and effective and help people avoid these mistakes? So, major themes today. I can't emphasize enough keeping things simple, planning ahead, staying organized, maintaining control of the things you create, and keeping it simple. So, I'll open it up to questions or comments. If you have any questions, Leo will run the mic to you.
I have a question as it relates to possibly trademarks or the concept of registering your company name with the state as a different process than just simply becoming a LLC. So, one, do you recommend, is that a two-step process, and do you recommend that they do that? And two, then, when you go to sell a company, selling that name or the process of how you make that switch or whatever. Great questions.
I think there's a couple of different things packed in there, so I'll unpack it. One, registering a company, forming, we'll just say LLC for right now. Forming an LLC, go through the Department of Financial Institutions. That gives you the right and exclusive use of that name as it pertains to a business entity called that thing. You don't even need to use that name as your business name. And if you don't need to take any additional steps. You could be like Drew Co. and I would call myself, ABC Professional Services. There's no need to register as like a DBA or doing business as. So that's one layer. And I strongly recommend that people actually form entities. As it pertains to trademark, there are a couple steps. And there are a couple levels at which trademarks are valuable. The first and most fundamental is just using it. That is your most powerful weapon against trademark infringement, and it's your most powerful exercise of ownership. Let's call it Drew Co. The more I use Drew Co. in the public, whether it's on my letterhead, if it's on my products, if it's on any marketing materials out in public, it is mine. It is my trademark. And the longer you use it, the more powerful it becomes for you. And that itself, there are a lot of automatic rights that inure to owners of trademarks just by virtue of owning and using them. Now, you can take those a couple steps further. One is on the state level. There is a state trademark registry, and I emphasize the word registry because it's not like an additional certification, and it doesn't really give you much power. It serves like actually using your name to put people on notice that you're using that name. I think it's a $15 fee, and one sheet of paper you say, I want this trademark. And they don't do much searching, and they certainly don't do any back and forth as far as, well, is it appropriate that you use this name in this particular industry? They just put it in their files and say, well, it's on record now. And there isn't even a searchable database online that I know of. So the value is pretty limited. I would say buy yourself a couple cups of coffee. Or go out and graffiti a wall with your trademark on it. Now, the other step that I think is and has a lot of potential value is applying for registration with the U.S. Patent and Trademark Office. They oversee patents and trademarks, obviously. And what you can do is apply to have that mark, let's call it Drew Co., in one or more classes of goods and services. And there are 45 classes, and it's pretty weird how they're broken down. Like class 10 is surgical and medical apparati, specifically, latex, silicone, durable goods. Okay. And I mean, they're pretty diffuse, but your challenge is to craft a description of what your goods or services are, and then shoehorn them into one or more of these these categories. And what that does is that, again, puts people on notice that you're using the mark. But if the PTO comes back and approves your registration, which can take up to a year, then you are empowered to sue infringers in federal court rather than just in state court. But here's the thing, if you just are using DrewCo out in public and someone comes along after you and starts using DrewCo and it is potentially confusing with your mark, then you can sue them in state court and win. So, hope that answered your question. If you're selling that, so if, when you sell a company, there are two different kinds of company sales, stock sale and an asset sale. And in either of those situations, stock sale is like, I own 100 shares of DrewCo and there's only 100 shares. Now they're yours. Everything with the company, all my liabilities are yours. Goodbye, I'm moving to West Palm Beach. An asset sale is I have 100 shares of DrewCo and I have desks and computers and money and customer lists and intellectual property. Those things are all yours, but the liabilities remain mine. So in both of those situations, you have sold a thing called your intellectual property. And in all those documents, as you're closing, you'll have warranties that say, 1, I own all these things that I say I own, like DrewCo, the name. And 2, now you own DrewCo. So that's significant. You would mention in those documents, if you had registered it with the PTO, you would say, trademark registration serial X, Y, and Z. If not, you would just list it as, all intellectual property. You would say the mark DrewCo. So in sales, I haven't run into many where it's significant whether it's registered, just that it's, defensible. And just one final note is when you're using a trademark, say DrewCo, you can always put the superscript TM to say that it's my mark. You don't need to take any steps to do that. Once you've registered it, then you can use the R with the circle around it. So, hope that answered your question. Yeah, Dan.
If DrewCo gets sued, like for, let's say, patent or trademark, and you have to defend yourself, and as a startup, let's say, you incur significant legal fees to defend yourself.
Yeah.
If you're successful, can you recover those fees? Because one of the items that would discourage somebody from pursuing the infringer is just how much it might cost, right?
That's a case-by-case basis. Typically, if you win, it might be part of the order that the other side pay your fees. It really depends on the posture of what the case was. If someone was, had brought a suit against you that was frivolous, it's more likely that they would have to cover your costs. If, typically our system is that you pay your own way. And that, it's like you said, Dan, it's a great discouragement to engage anybody, and this is the problem with what are called like patent trolls, where there are these companies that are out there that want to more or less squeeze money out of startups. And one, startups don't have a ton of money, and 2, they have even less money for legal fees. And any kind of litigation, whether it's patent or any sort, can easily run into hundreds of thousands, if not millions of dollars of costs.
So say you're operating your startup in the open source movement. How do you deal with intellectual property if you want to make it as transparent and open, to the public as possible? And I have a follow-up question related to cooperatives as well.
Cool. Yeah, great question. This is a very important issue in the software space. Obviously, there are a couple components to it. One, you can't take something that's already open source like Apache or Unix and claim that it's your own, even if you make subtle changes to it, because that would eviscerate the whole purpose. But I guess the multi-part question that I hear is, one, what do you do if you have created something significantly different and unique out of something open source? And 2, what if your purpose is to be open source? For the first one, I think it sounds like it's the second question that's more important right now. So the first one is, talk to a patent lawyer, frankly. He or she would be able to tell you more succinctly whether, you had made a significant improvement that's so different and patentable that it's no longer, that part of it is no longer open source. To your question, though, Garrett, I think it's more or less inaction. I mean, you're not going to pursue patents on something that you want to be open source. And if your plan truly is to put something into the public domain, then you don't need to take a lot of additional steps. I mean, I think that seems rare comparatively these days, just because everyone wants to own what they make. But I think, there is the philanthropic software movement too. So.
And then, do you have any advice about incorporating or structuring as a cooperative? I know there's some funds within our city proper for emerging cooperatives and transitioning businesses from LLC, for example, or an LLP to a cooperative. I just wondered if you have experience with that or can speak to that.
My experience is more in LLCs, corporations, and I do some non-stock corporation work, so nonprofits. There are a couple people in my office that I'd direct you to. So, yeah. I know my limitations. Anyone have any questions about antitrust that I can't answer? Sherman Act.
Quick question. So I think entrepreneurs today have a lot of kind of DIY options, things like LegalZoom. Can you talk a little bit about when those are, good use cases for those versus go to your lawyer, or I guess find a professional service that is your lawyer, and where to kind of use one versus the other?
I mean, that's a great question, and I am torn because as a lawyer, it's my duty to say those are garbage and you should never use them. But as a human being who has owned a small business and who realizes the limitations of being someone who doesn't have a ton of money for legal services, I think there are suitable situations. And don't tell Joe Boucher, I hope he's not watching right now. No, he doesn't know that kind of technology. Oh my God, what if he does? Anyway, so I think, in situations where the one I can think of is if you're a sole proprietor and you want to take care of organizing your entity and setting up a very basic operating agreement. I think even the step of entity choice and organization is a space where startups can use LegalZoom. Frankly, when people call me and say, hey, can you set up an LLC? I say, I could, but, it'll take me 5 minutes. It'll probably take you 6. So, I usually just get on the website with them and walk people through it, or say, hey, take a crack at it. If it's hard, we can talk about it. Stuff like that. I think similarly, a lot of the logistical stuff like obtaining an EIN for your business, so an employer identification number, you're doing your business tax registration with the state Department of Revenue. The things that don't require or don't have a lot of decision points as far as how your company is owned, operated, or structured on a very micro level. So I think even if you have a partner, you're really best off at least having an attorney review documents. The question lingers about employment law too. I think there are some lawyers that say, LegalZoom and some of those companies have decent employment agreements. I disagree because employment law changes all the time and it's, state by state. I don't know. Irina, do you have any insight on this? You work at a company that has a lot of startup-like issues. Not to put you on the spot, but...
I'm using LegalZoom and things like that, like DIY legal services.
Those are all great services that you can use at no or low cost, and it's a great alternative for a lawyer. However, if you do want a more comprehensive advice or document, spending a little money on a lawyer is worthwhile.
I agree. I mean, this sounds biased, but it's steeped in my experience, which is more often than not, if anything goes wrong with people who have used LegalZoom, it is almost directly related to those documents, and unraveling them and fixing them is 10 times more costly than having me do it in the first place. And that's, this speaks to the overarching issue of how do we package and sell high-quality legal services that are truly better than LegalZoom, but compete with them on price. I mean, I'm never going to do a $39.95 operating agreement for you, but if we can find a way for me to do a $500 operating agreement that has a relationship baked into it, and the back and forth that you just can't get from online. You and your LegalZoom.
Yeah, sorry for interrupting, Drew. Sometimes I look at the agreements of the companies that they just took off the LegalZoom and just put their name on it, but it reflects nothing what the company does, and it's just a general template that is not specific to your company, and then later on a lot of issues arise because of that.
Yeah, absolutely. That's a great point. And I mean, we see that most often in, you see non-disclosure and confidentiality agreements, which are very popular these days, but are becoming things that have to be very specific, or else they're meaningless and unenforceable. So if you just pulled a mutual non-disclosure agreement offline and it says confidential information shall include all books, data, software, innovations, inventions, ideas, blah, 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 but you're not actually speaking to, if you're actually talking about, like, I don't want you to know I don't want you to tell someone about my financial data or my projections for 2016. You have to say that, or else it's just too diffuse. Same with employment. Like, if you try to, all these LegalZoom documents have stuff like you can't work for any competitor within 100 miles for 4 years, and that's on its face unenforceable now. So. Any other questions? Yeah.
So as a service provider, you mentioned equity and vesting equity and talking through with service providers about that. How do I protect myself in those types of conversations that I'm having with a budding entrepreneur?
Yeah, that's a great question. It's one that we ask ourselves a lot, and I think from the lawyer perspective, we're more naturally limited in how much equity we take because our malpractice carrier really doesn't like it. But it's always a conversation, and I think the issue that arises, one is not just is the vesting fair, or is it an equitable arrangement, but also what happens if the company just goes out of business? What happens if a lot of times, I'd say more often than not, that equity turns out to be worthless. So I think what I've seen as I represent professional service providers is trying to do some combination of cash and equity. Or equity is more of a kicker than it is the real piece of incentive to do work. I think, especially with, marketing in particular, but also software development, graphic design, those are valuable services, period. And I think that's part of our education to startups is that, you might not have to pay my 100% rate, but because it is valuable, you pay 75%, and then we talk about sharing down the road. So.
Any final questions? Yep.
Oh no, lawyer question.
Lawyer question.
So Drew, can you shed light on, I know there's a little misunderstanding in the community as to, for instance, hey, I'm forming my own food delivery company, however, I know another company that does it, however, my process is more efficient and doesn't involve that many steps as the other company does. How do I protect that process itself?
That's a good question, too. So in situations like that where you're probably not looking at a patent and you can't necessarily copyright a process, because you can't. And this is a question that I run into a lot. My advice usually is, and this is kind of beating around the bush, or kind of avoiding your question, but do the best at your process as you can, and try not to worry about, actually shoring up the intellectual property component of it. I guess this is for companies that don't, or that have to make the decision between doing the thing that they're doing or putting money into protecting the thing they want to do. And I think more often than not, just be the best food delivery service that you can. And that sounds very unlawyerly, I realize. But, when it comes down to it, there isn't a very clear way to say, oh, I need a piece of paper that says my process is protected. What I would, caution people against is to make sure that they're not ripping off anybody else's intellectual property that has been protected. So there's the two steps to that. One is developing your new and innovative process and being the best at it and really crushing the market. The other is looking hard at your process and saying, well, is my process the same or virtually indistinguishable from someone else's, and are they going to come after me for it? And if they're not, then I think the focus can shift to just actually growing your business. So. realize that wasn't very much of a legal answer, but
No, I think it's a very good answer. What do you think about asking all the parties that you talk to, about asking them to sign like non-disclosure agreements? How practical is that?
Well, I mean, you have to think, one, what is your purpose? Are you afraid, or what don't you want to be public knowledge? You know, if it's confidential information like your sales projections for the year, I think the concern is that you don't want the person or company that you're disclosing to somehow use those against you. Like if you were talking to an investor who said, okay, well, how many units are you going to sell this year? And if you tell them and they talk to a similar company that they're thinking of investing in that's going to sell more, that might color their interaction with you negatively in that they don't invest in you. I think the other layer of that is if you have something that's like a trade secret and, you know, in order for it to be valuable, it has to remain a secret, then you have to be really circumspect about who you're talking to and why. You know, do they need to know the secret sauce? Or do they, I mean, if you have a cool food delivery process, that might be enough that you have an open exchange and don't necessarily need the confidentiality agreement with respect to that. But if you're going to tell them either the financial projections, or if you have a truly trade secret that protects and somehow makes your process new and innovative, then I think it is worthwhile. But I mean, underlying all that, you need to look at the potential relationship. So.
Thank you.
Great. Any final questions? No? Great. Well, thank you, Drew, and thank you, everyone, for coming today.
Thanks, everyone.